So let's get started with part one of our LEX talks. And it's my pleasure to introduce to you Nicole Shanahan. Nicole is a longtime friend and member of the CodeX community. She was a residential fellow here. I believe it was 2016 or so. Oh my God, years fly by. But Nicole is a legal tech innovator, supporter of many projects, and yeah, we're thrilled that she will be running this session. Nicole, over to you.
Hi. So I've been participating in FutureLaw for about 8 years. 8 years ago, we were a group of 9 people sitting in an office in there talking about how quickly we were going to grow our startups. And Pablo's laughing because he was in that room. And it is not quick, is it? But, you know, there's a lot of tenacity in this room. And that's what makes this a special group. So we love getting together as a community. We energetically quibble about how inefficient the legal industry is. We are truly a group of proactive complainers. And I love it. But jokes aside, how amazing is it to see this conference in its 10th year? It survived a once-in-a-lifetime pandemic. And you know, now we're both equally in person and online. I think our numbers are about equally weighted, which is very cool. So we are both in person and in metaverse. And I just really want to highlight, Roland, your tenacity in bringing us all together. This was not easy to pull together, and certainly last year's virtual one wasn't easy as well. So thank you, Roland. So about 7 years ago, I was asked to put together a fun interactive experience, and I asked my friend Scott Hassan for 2 of those beams. Beams were those mobile devices that people could come and drive around a conference. I invited a young Russian computer scientist who was going to launch something called Ethereum, and that was Vitalik Buterin. And if you remember, his head was rolling around this room. And so I just want to highlight that, because had we all invested in Ethereum that year, we would be hosting this on a giant yacht in the Caribbean. But yeah, so this conference really is very important. We do try to cast a net to capture the breakthroughs that matter the most. And I would say we're doing a pretty good job. So this year we have a wonderful lineup of LEX Talks, which is a segment of the program that highlights breakthrough academic research and moonshot projects. This section today will cover topics on smart contracts, blockchain, elasticity and NLP, and water law. We'll start our program hearing from some of legal tech's originalists, Oliver, Dan, and Margaret, or CodeX OGs, as I like to call them. And we'll see insurance is a really big theme this year. It continues to be painful to all constituents. Administrative costs are around $270 billion annually. So I'm hoping that this wonderful crew here is going to help us reduce that cost. Quick introductions. Oliver Goodenough, Director of the Center for Legal Innovation at Vermont Law School and a visitor at CodeX. Dan Siciliano, Director of the Federal Home Loan Bank of San Francisco and Chair of the American Immigration Council. And Margaret Hagan, Executive Director of the Legal Design Lab and lecturer at Stanford Law School and the Stanford Institute of Design. Thank you, guys.
Wonderful. Thanks. So for this first part of the panel, we're going to talk about insurance. And I'm going to kick it off by talking about a recent class that myself, my colleague Nora El-Haider, and Roland taught together this past 9 weeks in winter quarter here at Stanford. We put out Facebook ads around the country saying, do you have 30 minutes and do you want to talk to us about your health insurance contracts? We got hundreds of people to sign up. And then in our class with our wonderful team of law and computer science and policy students, we spent most of January's classes on Zoom calls in therapy sessions with people about what they go through to shop for those insurance contracts, understand the terms of them, and then try to make use of them when they have a medical emergency or a possible reason to go see their doctor. I just want you to take a minute and think, what would you answer if I asked you, what do you think about when it comes to health insurance contracts? How is that experience for you? Is it good? Is it bad? Tell me some of your most frustrating stories. 30 minutes is not enough. So we interviewed many, many people from around the country, and in two main groups that started to make clear. Proactive folks, maybe some of you are like those. I think I'm a proactive person who wants to shop very strategically, make a really good choice for me and my kids and my husband because no one else in the household is going to do it. And then whenever there is a burn, whenever there is a pain in the back, whenever there is some kind of thing to go see a doctor, trying to figure out what is actually going to play out when it comes to finances, the contract, the terms, and all of these different parties. And what we heard from people, what we were trying to do with this class is identify where are there key opportunities where computable contracts and this insurance initiative that CodeX is spearheading, where are there ways that better contracts, smarter contracts, more infrastructure and tech could make these people's lives better? And we didn't solve that. I think we'll hear some of the promising directions from Dan and Oliver, but I wanted to highlight some of the needs on the ground that we were hearing from people across the country. And probably some of them are familiar to you. And the second group was reactive people. People who are coasting along, probably have never had a medical emergency, are just happy to be insured, but don't really know all of the problems that await them once they do try to start making claims or have to make use of it. One message that we heard very, very clearly, and that I think computable contracts could play a role in, is give me consistent information. What we heard from many moms, people who are trying to make use of insurance contracts, is that they are having to do so much background research. They are calling the insurance customer service line 3 different times to try to get a reliable, consistent read about how their contract terms will play out for a given medical scenario. And then they're not just stopping there because they do not trust the insurance company. They're going to Reddit. They're going to moms' Facebook groups. They are going to their moms' WhatsApp groups, trying to triangulate, how is this actually going to play out? What is the ground truth? Who can I rely on? Hopefully there is a future where there is more reliable interpretation of how a contract applies to a person's life situation. So you know if I go to this provider or that one, how much is that is going to cost me? Or if my condition is billed in this way or that way, how will that play out for my child? Another thing that people really wanted was a mixture of transparency and kind of scenario playing. So they wanted to be able to see what the customer service representatives or the insurance or the healthcare providers see. Let me see what the actual prices are, what the billing codes are, and if I go into a certain provider with this billing code, what that price consequence is going to be for me. Give me a calculator. I will spend 30 minutes before I get in the car and take my kid with a broken leg to the hospital to do some strategic decision making if you give me that kind of calculator or chatbot, something to help me plan and make a strategic choice, not just when I'm shopping for insurance, but right before I'm about to use a healthcare service. And especially for our more reactive users, let's say if you're a 26-year-old and you're no longer on your parents' insurance and you're just in this mystifying new world of insurance products, what we were hearing from those kinds of users is just make it easy for me. Like make it transparent, especially when I'm at that shopping moment. Let me see, let me do a little bit of comparisons, but give me computable contract-based tools that make it as easy as possible for me to be strategic, because I'm not going to Reddit or moms groups to do all this background research. I want to be a smart consumer in the lowest touch way possible. So some of those themes, I think, present really interesting opportunities for tech, data, better contracts to solve. So I think I'll hand it over to Dan and Oliver to pick up on where some of those, what can actually be built to help address these needs.
Sure. Thanks. Thanks for having us. I think I'll just take about 2 minutes to lay the groundwork as to kind of what the big picture is, and I'm going to hand it to Oliver to get into some details. But there's nothing more riveting than the perfect trifecta of insurance, lawyers, and contracts. And then you follow that up with, and we're going to focus on the contracts, right? And the technology of contracts. And people are like, oh, blockchain, AI, natural language. No, none of that. Computable contracts, right? So weirdly, we're the now law version moment of future law, as opposed to future law is kind of like very near future law. And that's actually both the two-edged sword of this area. So computable contracts, when we talk to industry and we talk to other folks who aren't engaged in them at all, especially in insurance, and I think Oliver literally got this question last week in London, they say, well, how long really until it's impactful enough to move the needle in my organization? And the honest to goodness answer is 1 to 3 years from when you start. It's all about implementation. There are no massive breakthroughs that are required. There's some coordination, there's some standardization, hopefully Mike's not in the room, some other things that have to be pulled together, but they're all execution. There's nothing, and that's actually why it's kind of boring, because it's not nearly as exciting as the metaverse, or I'm not doing anything, like a robot won't come up and fill out your insurance forms. Nothing great, right? This is just solving the consumer side problem, but imagine the insurer's problem in this story. So we've been issuing repeat lines of insurance for 20 to 40 years for our most loyal, dedicated small and medium businesses around the world. And then there's this COVID thing. And our evolution of how we treat, interruptions to business and, acts of God, and it's changed over the decades. And so I, as the CEO, ask a simple question. So what's our exposure on this COVID thing? How are we going to do that? And the answer is we need to send 5,000 people into 4,000 warehouses to dig up 250,000 files so that we can then analyze them with another 8,000 people across the next 40 days. Wow, that's a bad answer, right? So what would be really cool would be able to say, oh, let's see, in this jurisdiction, here's the exclusions that we managed to get in, except for these, so we can get them to those. Just imagine your ability to just run analysis on top of your, wait for it, the reason it's so exciting, the contract is the product, right? So in insurance, it's so elegant. Everything else, it's a little bit more of a stretch, but literally, the contract is more or less the product, right? The rest is kind of window dressing. So wouldn't it be great if I were, and I do banking stuff, so in a bank, you couldn't say, well, we're not really sure if those are rubles or if those are pesos or US dollars, kind of a mix, but I'll have to go look in the drawer. That would be unacceptable at every possible level, but in a weird way, and no criticism meant to the insurance industry, because it's one of the great inventions of all mankind, right? Of humankind is that insurance, right? Insurance is a great invention, but they've evolved over 300 years. And so this is kind of the natural next step, which, and I'll hand it over here, requires no real breakthrough in terms of the fundamental technology, which is why people get a little bored, because I think we're all here, right? We all like the next thing, not the thing that I can do tomorrow, because that's a bunch of executives who have to make decisions and sign contracts, and ironically, and do all sorts of other things. So that's the backdrop for moving forward. We think there's a huge solution for, can I just get an answer as to whether or not my kid is covered before I pay the bill, please? And for the insurer to say, do we know if it's covered, and do I have to keep paying people time to reread contracts again and again and again? And 1 out of 5 times it gets escalated to a lawyer because they didn't understand our own contract, right? So we solve that, or so we think. That's
or we're solving it anyway. They have set me up to be the one to now get you enthusiastic about this project, all right? Yeah, okay, because it is actually worth some enthusiasm. One is the social benefit, the benefit to consumers that's potentially there, the benefit to the companies that's potentially there. By the way, we have a website, CodeX Insurance Initiative. It's got white papers and all that stuff, and discussion papers that will lead you through all the potential benefits. They're legion. But the reason it was really interesting to us at CodeX, which is a research center on computational applications of law, is this is a really cool use case. It may not be exciting in some ways, but if we're looking to ask what area of the law can we use as a use case, what area of law, business, society can we use as a use case that will help us move the needle forward on this, the project of putting law into code. I mean, that's one of the CodeX's big projects, is figuring out how do we do that well, how do we do it responsibly, how do we do it in a way that's going to be good for society and not terrible. All of those questions come this is a place where we can really try that out. As it said, it's not like we don't have a reasonable understanding of the stages we're going to go through. Obviously, we'll learn as we go. But we haven't really tackled a big area of law and just done it. And this gives us a chance to do that. We're happy to work with our friends at AXA in particular, who have actually are doing it. They're the ones who've already committed a couple years to this thing, and they've got products.
He's pointing to some of the fellows who are here
Right.
from AXA as he points to the back.
But basically, this lets us build these things in a way that we've been searching around for a bit for a project that was both tractable in size and interesting to do. So our project here has really three principal components, the CodeX aspect of it. One of them is research, relatively pure research, and there's some research to be done on the computer comp side. Mike Janesrath, who you saw, is spearheading that. We're really focusing in on the kinds of software and computational approaches that will best help us to do law. And our own focus has been on the logic programming side, which we think is particularly suited to this kind of contracting. We're pushing some stuff ahead that is going forward. Second aspect of research is the law itself, because it turns out that one of the key steps in this is taking the law, reading it afresh, reading it as if it were a computational statement already, reading it as though we were disaggregating the different pieces. What is what we sometimes call the local logic of this transaction? How does that logic structure carry over in? So there's a great deal of research on that law side as well, really helping us understand the computational nature of law. Then there's applications. We're working with some folks. This is a little more applied. This is in some ways what Margaret is up to. If you actually then begin to roll this out in the way that people and society and all the rest of it want it to happen, how do you make those choices? What are the stages that it interacts with the business process of insurance? What are the stages that it interacts with the human process of consumers and the insured? How does it interact with the regulatory structure, which is very heavy in this world? So we've got a bunch of quite interesting application contexts here. Third big segment of this is community building, because a lot of the problems we're facing in this, the solutions really are community solutions. They're not individual solutions. They're, yes, individual companies, yes, individual consumers, but they're basically bigger systemic kinds of questions. Things about interoperability of data, things about the regulatory aspects and what's going to be permitted. So we feel that having a community both to exchange knowledge and to be active in helping solve the community scale problems is important. So that's a third piece. We yesterday had our first big sort of in-person gathering of the community we're building. It was I like to think a success. It was a lot of fun. I learned a lot. We had a number of very interesting participants, and we're hoping to build off of that. So happy to talk with you all about this further. We've just give you a little teaser taste, a tasting menu version of the project here. If there's anybody who in the audience who would like to come see the three of us or others parts of the CodeX team on this, and we would be happy to discuss it further.
And I do want to call out AXA for their kind of leadership role, but also the principles that are driving some of this. So one, our work is intended to be in the end open source because we think it's important for it to essentially be available to everyone because it enhances and has so much social benefit. But even beyond that, most insurers are coming around to this, I think, but AXA has been a leader in this from the beginning. They have a vision that the insurance transaction at the moment is on average, especially for like personal lines and consumers, distasteful, but what if you could really transform it? I mean, the exercise of insurance is highly positive. It is a really remarkable, wonderful thing. What if that could be experienced as a net neutral and net positive event? Like you felt like someone had provided a solution to you, and that in the end, if you could do that, and then you could get really sophisticated about what we've come to call, mass customization because of the efficiency of this type of implementation, you could imagine a massive expansion of insurance. And insurance itself is not a deadweight loss. So we're not talking about being on the phone more. What we're talking about is being able to insure for little things and big things on the fly in a very seamless way. And that's really a great vision. I mean, it has such positive social impact. So those are the underpinning fundamentals that I wanted to throw out beyond that.
The two words I'm going to say before Nicole shuts us down here is going to be, it also helps analytics. All of this kind of data is going to help analytics.
It probably enables all that blockchain AI stuff, right?
So anyway, come talk to us. We'd be happy to hear from you and tell you more.
And thank you guys. Margaret, I don't know how many hours you have in a day. I have 24, but based on how many projects you're involved in, I feel like you must have 60 or 70. Is that true?
No, I wish.
Well, another amazing project you're involved with involves making courts more accessible, the court process more transparent and fair. Could you tell us, please, more about your Filing Fairness Project?
Yes, thank you, Nicole. I'm going to show slides here. So hi, everyone. I'm going to switch hats, not talk about insurance. I'm going to talk about another project that the lab that I run, the Legal Design Lab, and the Center on the Legal Profession at the law school has started last September. It began as a 2-quarter class. So we've had wonderful students from across campus here, law students, computer science students, policies, humanities students. And my co-leads on this project are Professor David Engstrom and Mark Chandler, who recently retired as the general counsel of Cisco. Our inspiration for this project is, why is filing a court form in the United States so hard? I don't know if any of you have ever had to file a court case, meaning getting that piece of paper over the transom into the clerk's office and having that clerk accept it, that now you have either filed a lawsuit or answered a lawsuit or done some other kind of act of filing. But we know that this is a problem that really has big life consequences for people. My focus is on evictions, and in many states, like in California, if you are a tenant and you're sued by your landlord for an eviction, for an unlawful detainer, you don't get a hearing automatically. You don't get a day in court until you file an answer within a short window. And you have to get that piece of paper that explains your side of the story into the right clerk, in the right format, with the right fields, to be able to defend yourself against this life-changing event. Same thing with getting a restraining order to protect yourself from harassment or domestic violence. If your employer is not paying you fairly, to raise a claim of wage theft, or even to try to expunge your criminal record. All of these government processes, government services, depend on a person being able to get this piece of paper, or more really these data fields, into the court in an acceptable way. If we had more time, I would ask you to try to actually figure out the processes, the forms, and the steps to digitally try to e-file something in California. But the short answer is it's very hard, mainly because many of the things we've already talked about. There's fragmentation at the local level. When you do a Google search, you might end up at the state site and find a state form with state rules, but then you'd actually have to file it, let's say in Santa Clara County, where there might be local rules about what staples you should use, how much margins there should be, all of these things based on a paper version of data fields. Many of filling out the form, even if there is a software, is often clunky, slow, and burdensome. Procurement contracts that courts have with technology providers have not led to fast, quick, and responsive tech. Also, when there is innovation, like let's say a university lab partners with a court and makes an amazing product in Tulsa, Oklahoma, or in Boston to make it really easy for a litigant to fill in a form and file it, it's very hard for that one-off solution to scale beyond that one jurisdiction. Because guess what? Every state has different ways that they label those different fields they collect on that piece of paper, or they have a different list of fields that they collect, even if it's basically the same situation. And when that individual platform gets built, like if my university lab wanted to work with the courts here and build a great solution, there's not a sustainability plan to keep that platform working as the web changes, as tech changes, as device changes. So many of the good innovations that might have come about 15 or 20 years ago are kind of old, outdated, not being run in a sustainable way. So that's where our project, we identified those key failings in the fall, and we've been working since then to identify a promising pilot. And what we have come up with is a 6-state pilot where we are getting to a multi-jurisdiction pilot, where we start to work on national data standards around what those fields are called on the forms and how courts actually accept filings. All of those boring little things about, does the form need to be notarized? Do you need a wet signature or a digital signature? And our real goal here is not for our university to build the ultimate solution that all courts will buy. Exactly the opposite. We want a healthy marketplace of many different for-profit and nonprofit tech providers to be entering into this space and building national solutions that are current, responsive, meeting all those standards I set out in the previous slide. We want a healthy marketplace of innovators to be serving those consumers who need to file forms and follow along their court process. And right now, there really isn't that much of an ecosystem in this space. So we're aiming for scale, and that's something I know in the United States is really hard to do because of our decentralized 50 laboratories of democracy, if not every county being its own laboratory. So we need this community building that Oliver was talking about. So in that effort, we have 6 states where we have the state Supreme Courts and court administrative offices agreeing to help construct data standards around these form fields, as well as common protocols that then tech providers can know if they build a product, they can serve a sizable part of the American population, have a much larger market than they would if they're building for one county or even one state. With our 6 states, we have about 1/6 of the American population. So it's a sizable market once you start to get jurisdictions together. So what we're doing, and you can read more at the Filing Fairness Project at the law school's website, I'll just touch briefly on our 3 main pillars. The first one that I've been talking about is this common form field coordination, data standards. The second one is about lowering the administrative burden, the time and money it takes to actually file something, and having more best practices around setting up that filing journey. And then the third is really being thoughtful and strategic about how courts or other government actors can foster more innovation at that healthy marketplace. So on that first, what we've been doing, what students have been working on since January, and that we're going to continue in our pilot, is taking all of these state court forms. We started with name change, that filing experience of trying to change your name, as well as eviction answers, and also asking for a filing fee waiver so you don't have to pay money to file the forms if you qualify. And taking all those fields and making them into giant spreadsheets and showing to the courts that they're not all that different. Even if they are calling their fields different things, or they're putting middle name together with first name or address in a different way, that with a few small changes, they could be standard across their many states for the fields that they're asking for. What we're not asking the courts to do is to change their forms. That is a huge bureaucratic process. We do not want to get into long political battles. What we are asking them to do is to consider receiving and accepting filings that come across their clerk's computer system or desk. If they have these fields, then they will be accepted. So the current forms that have gone through many committees still are okay. You can have your local forms, but you will now accept fields that come in through an e-filing system or otherwise that contain these national data standards. So we're trying to avoid all of these local battles in that way. The second pillar is not just about getting those fields right. After all of our research, we realized that it's a whole journey to get a form into the court. So we need to make sure that litigants who do not have attorney bar numbers are also able to digitally send their document in. In many states, they're not allowed to. You have to have an attorney bar number and be licensed to send your form in digitally. So whether a court is at the beginning stage with just an email system, or if they're, like Texas, very robust with a wonderful statewide API, that they're able to accept filings online, that they're reducing all of these burdens around notarizations and wet signatures. Many states actually piloted this during COVID, and we're trying to encourage them to keep these emergency measures as permanent, and then easing burdens around cost and fee waivers. And the third pillar, and this is kind of more broad, less about the courts themselves and more about building this community. So first of all, making it much easier for tech providers to get certified to be able to file on behalf of litigants, but then also really taking a step back and saying, what are the business models that could be values aligned to access to justice, but also produce sustainable revenue, so that if a group is building a solution as a nonprofit or for-profit, that they will stay in the space, they will not pivot away, they will have a sustainable product that can still be excellent 10 years out and not just in the next year. So we're in the middle of those kinds of strategic brainstorm sessions about better innovation models. So I'll end there. I'll just say that if you're in this room and you're a tech provider who's thinking about consumer-facing solutions, I'd love to talk to you. If you have ideas about kind of data standards, business models, innovation structures, please be in touch. We're just kicking off this pilot from class phase to real-world phase, so very excited to talk more. Thanks, everyone. Oh, questions? Yeah. So Nicole's saying we have time for questions? Yeah, wonderful. Does anyone have questions? Oh, great, that's.
Thanks. This is terrific work. I was wondering, I spent many years on standard setting in the 90s and early 2000s for state court electronic filings, and have you looked at any of the standards out of OASIS?
Yes.
Did you see any data model or any fields there that were helpful? I know there's a whole envelope and a bunch of stuff you wouldn't want.
Yes. So the electronic court filing standards are wonderful, and we are coordinating with them. I think our fields are like a step before that about all the substantive issues that a person needs to present their life story into the eviction fields or the name change fields. So it's more going into specific domains of law or case types and getting those fields of the substantive law mapped out. And then the existing data standards that already exist, coordinating to make sure if there is overlap, we're using those standards as well. But yeah, there is this healthy standards committee out there that we're happy to be coordinated with. Thanks, Datsa.
Thank you.
So I was going to ask if the extensibility and the contextualization of the schemas is the primary issue, whether you've looked into extensible schema formats like JSON LD and structures that allow you to sort of recursively enrich things based on their context rather than trying to pre-specify the whole schema, which is inevitably problematic.
I think we are not there yet. Literally, our first effort, and a lot of this is not about the tech or the data standards, it's about the political will and showing states that if they spend time on looking into what's actually inside their forms and accepting a list of fields rather than pieces of paper, that they will not be deviating from what, using a national set of fields. If I was starting up a startup and I created an eviction answer list of fields rather than a piece of paper, convincing the courts that that list of fields is essentially the same thing as what they are getting on a piece of paper. That is where we are at. The actual, how we present the data dictionary or the data standards or how we are encoding it, that is a next step that will probably be a year from now, but right now it's the political question.
I would argue that in order to actually solve that political problem, you need to get that sort of there's something ontological about the fact that the tools exist for things to be naturally extendable rather than pre-specified, because if you're trying to solve the political level, then you need to be able to make, I guess, some sort of claims about what the resulting systems would be like, and their extensibility provides at least the toolkit to resolve, I think, the challenge you're describing, even if it's later that you actually do it.
Well, yeah, I'll take that. Yeah, I think we can take that back. But you would not believe the place where we are starting at, so yeah.
No worries.
Yeah, great. Okay.
I've worked on this, a similar project back in India. And the most mind-boggling sort of pushback that we got was that the reason we don't want to bring in low-burden filing protocols is because it brings in more litigants into the force, and it'll then create more pendency issues. Are you dealing with similar issues, and how are you responding to them?
So every state is different. So when we're dealing with a state like Alaska, which has an amazing setup but very, very low population, it's very different than working with Texas with its huge population. So courts are different in terms of, and also the urban versus rural, like in the state of Michigan where we're partnering, a place around Detroit versus somewhere in the Upper Peninsula. Judges are different about whether they want more volume or not. So this is an ongoing debate. Like I was saying, a lot of our discussions right now are getting that political will and clerk will to go to a low burden protocol. But we are trying to set these standards and hoping that our local partners can bring their whole state along with this. it's an experiment. We shall see. But yeah, I'd love to learn more about what's happened in India. Thank you.
Thank you, Margaret.
Thanks, Nicole.
Okay, we can't get past about 5 minutes before someone mentions the word Web3 or blockchain. This is the reality. So how do we teach this to students? How do we teach this to professionals? This is a very quickly moving field of technology and a body of law that we just don't have answers for. It's not going away, and we've got to somehow catch up. And Tony and Ruben have put together a blockchain education project, and it's a curriculum, but I think we're going to learn a lot more about it from them, because it really is a mapping of what traditional law is to a new paradigm. NFTs really are a recordation, can be used as a recordation of intellectual property. Smart contracts are embodied law in some ways. And we have to accept and define it. And I think that this is a really, really important first step. Come on up, guys. Oh, and Tony, quick introduction. Entrepreneurial fellow at CodeX and co-founder of Legal.io. Ruben Youngblum, who is the coordinator for the Stanford CodeX Reg Track initiative, as well as the co-host of the Stanford Law School Our Data podcast. Come on up, guys.
If this were tech, I'd figure it out a lot quicker, I think. All right. Hi, everybody. I feel compelled to start with an apology for breaking the no blockchain rule and bringing it. It's been a couple minutes, so I think we'll just dive in here. So thank you, Nicole. As she kind of said, I'm a fellow here at the CodeX Center at Stanford Law. I'm a lawyer and computer scientist by training. My real passion, though, is blending the two together. So when I'm not at Stanford, I also work at MIT in their digital currency initiative. I think a lot about digital currencies generally, both in the blockchain context and out of the blockchain context, how they can be world-changing, and more importantly, how they could potentially cause problems that we aren't anticipating at the moment. Think a lot about the ethics of blockchain and the impacts of the proof over consensus mechanism on climate. These are all things that I care very deeply about. Please come talk to me if that's something that interests you. So I'll just take a quick second also and plug a journal that I run at MIT. It's called Crypto-Economic Systems. I care very deeply about bringing research in from disciplines that are, as of right now, not represented well in blockchain research. So we're opening a call for papers probably around May 1st, so please get your papers ready to submit there. So I'm here, though, to talk about the Blockchain Education Initiative. The Blockchain Education Initiative is part of Stanford CodeX, but it sits under the larger CodeX blockchain group. And so I am going to take this second to highlight some of the other projects that are part of the CodeX blockchain ecosystem, just because I think they're really important. We have the Stanford Journal of Blockchain Law and Policy. And if you are not going to submit to Crypto-Economic Systems, please consider submitting to the Stanford Journal of Blockchain Law and Policy. You'll get to work with Stephen Nam. He's our editor over there, and so I would totally get it if you submitted there. And we have the RegTracks initiative, which is trying to kind of untangle the mess surrounding blockchain regulation. And we're in the data collection phase right now, and we'll hopefully move into data analysis in the very, very near future. A climate data policy initiative, which focuses on taking climate data and applying a more rigorous lens to it. And then, of course, the blockchain education initiative. So the blockchain education initiative grew out of a problem in legal education, specifically surrounding blockchain. So let's maybe take the people in this room out of the equation for a minute. But I found a nice chart that I'll put up in a second that I think really illustrates the relationship between lawyers and computer science. So I found this really great Venn diagram here that should illustrate that. So to be totally honest, so I stole this from Clay Shirky, gave a great TED Talk on decentralized governance. I stole it from him. I actually think he stole it from somewhere else. So please consider this my attempt to give credit where it's due. But I think this really it illustrates what's going on in the world right now. By and large, lawyers do not have a deep understanding of the tech, and yet they are the ones, generally, that are doing the regulation. So this is a problem because law students, at the moment, are the future, right? They are the ones that are going to go out. They're going to be regulating. They're going to be the ones making policy. And it's really critical that they understand the technology on a very deep level that they're regulating. So this matters because blockchain is important. I think Nicole alluded to it. We can't go 5 minutes without talking about it. With NFTs, with digital currencies, with 9-year-old millionaires that showed up because they got into blockchain and sold a picture of a rock or made a really good bet. People are really interested in this, and it's gotten into law schools, and how we teach it at the undergraduate and graduate level is incredibly important. So I put up here that law does not equal engineering, which that in and of itself, it seems kind of intuitive. What I'm trying to express is that lawyers and engineers are trained at the academic level to think very, very, very differently. It's a little strange sometimes. As a lawyer and a computer scientist, I wear different hats. And sometimes I'm the only lawyer in a room full of engineers, and it's really strange. Legal inferences that I find very intuitive, engineers just don't get. I've been in a room where I'm like, guys, we could do this, but we're all going to go to jail. And they say, but we can. We can build this. And I'm like, okay, well. That's fun for about a second, and then it's not fun anymore. And then I can also tell when I'm getting a little bit too far on the legal side, just to illustrate, the extremes of these two disciplines. I can tell when I'm on the engineering side, I can tell when I'm being a little bit too much of an engineer, because I get emails that suggest very, very kindly that maybe my social skills need a little bit of work, and maybe I'm not the right person to be going up and yeah. So there's a huge delta between the way that these two disciplines think. So I said that I didn't. The crux of this is in training students how to think. When you search for words on the internet, hopefully you use DuckDuckGo, you search for words like what makes a good lawyer. You get words like compassion, which maybe you take that in the way that I take it, which is a subtle dig at engineers, and maybe a fair dig. You get words like compassion, inference, storytelling. And the larger point here is that law is a very narrative pursuit. Our job as lawyers is to go up and tell a story. We're doing a lot of interpretation. We're doing a lot of narrative and world building, and that's how you succeed. With engineers, it's a little bit different. When you're doing engineering, your job, in a lot of ways, is to take all of the interpretation out of the equation. And that is just a completely different way of approaching the world, and I think that law students could benefit a lot from getting exposure to this mode of thinking. So I glossed over something a little earlier in these slides. It's the idea, went too far. The idea here is that good regulation requires a really deep understanding of the technology. So like I said, law students are the future, right? They're the ones that are going to go out. They're going to be the ones working at the SEC, at the CFTC, and I feel very strongly that they need to understand at the technical level what it is that they're regulating. Otherwise, we run a very real risk of over or under regulating new technology. So blockchain is moving so quickly. If we focus on what's happening right now and we regulate based on what's happening right now, as soon as the next innovation comes out, that rule is obsolete. And it's the kind of field where I'm sitting here going, okay, it's 2 o'clock. I haven't checked my email this morning. What happened, right? What new laws are being broken every second? And so my suggestion here for law students is to learn how to code, right? If you want to get into this space, if you want to engage in regulation, learn how to code. And same thing for legal educators is bring a technical curriculum into your law schools. This is, it's kind of hard to blend these two subjects just because they think so differently. Bright line, comprehensive rules, they're extremely difficult to put into law, although I will say my colleagues at CodeX are doing a great job at making some pretty amazing headway. And so are my colleagues at MIT. I just made eye contact with Brian Wilson, so I'll also take a second to plug the MIT computational report. Yeah, all right. Got some fan over there. So we've put together a number of initiatives here around blockchain education. So of course we have events and summits. A big part of our goal is to foster projects both within the CodeX ecosystem and outside of the CodeX ecosystem. We run hackathons, have a monthly meeting for the blockchain group. We've also put together a curriculum that is designed to bring coding education into law schools, which I guess didn't make it onto the slide, but that's really the crux of what we're doing, is trying to think about how can we take these two disciplines and merge them so that in 5 years, 10 years, the people who are going to be doing the regulating have a very, very deep understanding of this technology. And so I'm approaching this being I'm a lawyer who happens to be an engineer, but I'll turn it over to Tony for a little bit of a broader view, because Tony is a lawyer who happens to be a Renaissance man, is the best way I can kind of describe it. So yeah, these are all things that he'll call me like 2 in the morning and be like, hey, you want to talk about finance? I'm like, oh, all right.
So thank you, Ruben. I guess this builds off what we were talking about in terms of law students being the future. Certainly if we can help law students and lawyers generally see how they can play this role in the intersection between all of these other myriad disciplines, our hope is really to help folks see how blockchain is this opportunity space for lawyers to really engage across broader horizons of moral, practical, and philosophical concerns. So in that sense, with law and computer science, I mean, we're already starting to be able to see how these methods of coordination can be elevated to this point where you're using cryptographically fused building blocks to create these longer trust chains, is one way it's been put. But like, what does that mean? How can we unpack that into sort of sociological phenomena of that? We've already heard about how business models are transforming law. And so thinking about the economic side of things, what are those privacy versus sort of services trade-offs, and do they still exist? You know, in terms of like these sort of ethical approaches to governing economic models, these are all part and parcel, I think, of where lawyers, when stepping up to these broader horizons of like, how do we want society and economies to work going forwards, I think they're some of the most interesting questions that we can engage with as lawyers, and I think blockchain opens this opportunity. So we've talked a little bit about the financial side of things. We've sort of steered mainly clear of that, but when Ruben's talking about digital currencies, what gets me excited is the idea of local currencies, the idea of currencies that are perhaps backed by nature in some way, and we're able to track the underlying vitality of a bioregion and actually figure in some of that into our sort of more evolved financial system. So the talk right now is less about DeFi and decentralized finance and more about refi and regenerative finance. What does it mean for lawyers to be thinking about what those kinds of regenerative ethical business models that can be supported by financial mechanisms, which are ultimately all based upon multi-party stakeholder agreements? And it's sort of like the notion that, you know, blockchain as a multi-stakeholder party coordination framework is completely new is obviously, as we know as lawyers who've done any kind of construction or major infrastructural project, you know, there's nothing new about multi-stakeholder coordination. But as lawyers, we can take these frameworks and then look at, okay, this infrastructure is providing a totally new way of doing that. And so one of the exciting areas is actually, what do these underlying frameworks mean for all manner of different fields? And I've picked out decentralized science here because we're working directly with a few different organizations that are looking at the nature of institutions, the nature of academic work, and the nature of funding of that work. And you know, there are some very interesting problems in science that have been acknowledged by various folks, including things like replicability challenges, issues around the sort of sharing of evidence, the sharing of underlying data sets. And we're seeing DAOs and blockchain-based mechanisms, including with NFTs that are specifically around IP licensing rights. Again, talk to Jare, Professor Liu, if you're interested in any of that. But they're really, really helping to sort of reformulate a field which has so many different legal implications, and there's so many legal opportunities as well. And so I want to just finish this sort of very, very high-level look at what we at Stanford here at CodeX are doing with blockchain education and talk about our newest initiative, which is with the Institute for the Environment, the Woods Institute for the Environment here at Stanford, and a professor of bioengineering, Jan Liphart, his distributed trust initiative. And it's really a focus around education from the law and policy perspective around new kinds of collaborations focused on this notion of resilient society. So moving beyond this notion of sustainability to resilience across the board. And what does it mean to create societies that have an embedded ability to resist sort of like extractive mechanisms and actually form those local resilient frameworks for coordinating and governance around common resource management, nested accounting systems for an independent global stocktake, looking at where institutions like the nation-state system and COP are sort of behind the game in terms of their global stocktake that they're trying to figure out. And there are these wonderful groups of humans that are trying to look at, okay, let's coordinate between cities and corporations as well as nation states, as well as areas beyond national jurisdictions like the oceans, and how do we create this sort of nested accounting system for that kind of climate data. There are pathways to the notion of a carbon coin. I know, Nicole, you've been thinking a lot about that. Really excited that we're able to take lawyers and governance experts and have them go meet with sort of narrative experts like Kim Stanley Robinson and actually start thinking about, okay, what are the pieces that will be required towards creating this kind of legal, financial, and ultimately ecological collaboration that can maybe fundamentally transform systems. So I think there are a bunch of different lessons that blockchain can teach. I think to the extent lawyers and law students are thinking about systems change and thinking about some of these both macro ways that can be sort of shifted in terms of how we think about work, how we think about life, how we think about how we will live and work together. And then also on the local level, and what it means to have subsidiarity and polycentric governance frameworks in the spirit of Eleanor Ostrom, but actually applied now that we have some infrastructure to really start deploying those and crucially experiment with them. Because I think that's this last piece I'll land on in terms of education, and something that Stanford in particular has been very good to us around is actually giving space for that experimentation. And I think experimentation and doing and building as part of learning is one of the things that I've been so lucky to have here at Stanford, and it's a tradition that we're hoping to continue on with the Blockchain Education Initiative. So thanks very much for your time. Oh, yes. Oh, great.
Well, actually, as long as we're still up here, I'll make one more point, which is, and I should have mentioned, but that curriculum that we sort of developed is intended to be very open source. So if anybody is here on the faculty from another law school, please come find us, and we're happy to share what we have kind of built and learned to bring tech education into the law schools.
I guess you guys have fully educated.
Bruce. No, Bruce.
How do you want to take this discussion into the financial market discussion? Oh. How do you want to take, the spirit of innovation, but responsible innovation in finance? How do you want to bring that into the financial market participants? I mean, the regulators obviously are making policy, which we've anticipated. They will need some place to talk to about responsible behaviors. And how do you want to bring that into, let's say, a SPAC environment, or people need to know there's a good use of this stuff and a nasty use, and we can help to educate to that. How are you thinking we should do that?
Well, I mean, Bruce, thank you for the question. I mean, I'm looking at you as being one of the keystones of our approach to try and bring this sort of responsible conversation. A lot of the work that you've been doing around social banking and ethical banking and teaching here at Stanford about that is very much informed our work. So thank you for all the work that you do, Bruce. We'll be holding a gathering tomorrow. It's an invitation only, but if you're super interested in this stuff, that is designed to bring together some folks who've been looking at finance, who've been looking at natural capital systems, who've been looking at this notion of nature oracles and how we validate and normalize data about underlying biodiversity health and like feed that into markets in a responsible way. But there's a lot of challenges and a lot of pitfalls, and hopefully by gathering together in these sort of cross-pollinatory environments, in a, not in a sort of performative sense, but really in a jamming sense. We're coming together to, lay out the things that we're thinking about. We don't have certainty over them, but we're able to create an environment of guest friendship. Xenia is the sort of Greek term to actually open up and have that trusting environment to be able to speak to some of these vulnerabilities. And again, I think we're very lucky to have people like yourself, Bruce, to help to nurture those environments. Thank you, Nicole.
I was going to share an investing tip, but now I'm wondering if I can. But anyways, maybe carbon credits or carbon drawdown. I do think the tokenization of this is going to be very big, so maybe next year we can throw that on the agenda. Okay, I'm really into legal tech lexicon, but I don't know if this next one's going to stick. According to our next speakers, contracts drafted in natural language as opposed to code are now to be known as dumb contracts forever. Just kidding. It could be. I actually wouldn't mind if that stuck. But yeah, what I find really fascinating about Megan and Claudia's research is the fact that we could possibly eliminate ambiguous language in interpretations of contracts and interpretations of law. And in some ways, that feels very threatening, being a lawyer, because we spend so much time interpreting how things are represented and interpreting, various facts. And but at the same time, there's something also transactionally efficient and beautiful about it. So why don't you guys come on up? Megan Ma is the managing editor of the MIT Computational Law Report and a research affiliate at Singapore Management University in their Center for Computational Law. She's also the current residential CodeX fellow. And Claudia Glocka is a lawyer specializing in reinsurance contracts. Come on up.
So good afternoon, everyone. I guess what we represent here is some of the exciting research that is happening over in insurance and reinsurance that Professor Goodenough has teased. So hopefully this is a little bit exciting for you. So as Nicole alluded, vagueness seems to have a bad reputation. But is vagueness necessarily bad? As humans, the vagueness of our words may be a reflection of our implicit positions. That is, in certain circumstances, we feel it isn't the right place to commit. We may be hedging risk, or perhaps we simply do not know. In these scenarios, the use of vague language, infusing linguistic space, is not only regarded as acceptable, it's also highly intentional. The questions become, is maintaining linguistic space necessary? And if so, when do we need it? Here's where vagueness gets its negative connotation. There are indeed cases where vagueness is unintentional, or worse, it becomes an enabler of risk and dispute. Take, for example, when we asked that our LEX talks are going to start promptly after lunch. Instead, that was delayed a little bit to, I guess, around 1:30. Maybe better yet, at exactly 1:45. What is the intent behind these various specifications of time? Do we want to ensure that people return to their seats promptly and that we ensure a kind of fluidity in the process? Or are we now really forgiving because it's an in-person event, we're excited to see each other as opposed to online or remote settings? Closer to the home for the legal community, we frequently wrestle with the categorization, and specifically the act of narrowing and extending these categories. We may occasionally consider a burrito as a sandwich, or a tomato as a vegetable as opposed to a fruit, all of which the circumstances of when we do so may differ from when we don't. So why does this matter? In discussions of computation, specifically computational law, we consider how to translate between human and machine-readable languages. We are asked questions of defining, categorizing, and to be exact when doing so. Interestingly, in natural language or human language, there really are consisting of three underlying categories. We see syntax, which is the structure of sentences. We see semantics, or word meaning, and context, otherwise known as pragmatics. So curiously, computational models have largely focused on syntax and semantics, but have frequently neglected pragmatics, an arguably essential pillar when meaning making. This problematically impedes the capacity to appropriately understand and contextualize concepts. So by way of brief description, pragmatics is the field of linguistics that considers the contextual and the circumstantial environment of words. I may say there's an elephant in the tree. You may think, well, that's peculiar, for how can a prototype understanding of an elephant be in a tree? Well, maybe they're just incredibly strong sequoias. We are, in fact, in California. But as elephants are not typically found in trees, the notion of elephant alone represents the limits of semantic understanding. What we need is context. Is the elephant perhaps a paper elephant? Or is it a badly constructed idiom? The elephant in the room? All is to say, open texture and the fluidity of language use warrants further investigation, particularly as we transition to using programming and formal languages to draft and construct legal documents. Nevertheless, we are prudent to avoid the use of vagueness. And so we decided to do a little PR and offer the notion of vagueness a bit of rebranding. We call it elasticity. The idea of elastic language was first pioneered by linguist Grace Zhang, who asked how and why we stretch our words. She identified 4 key stretchers: approximate, scalar, general, and epistemic. We focus on epistemic stretchers that precisely characterize the attitude behind uncertainty and the lack of commitment. In this way, we may be able to better understand the reason behind elasticity to determine whether it is indeed strategic and/or intentional, or merely a consequence of conserving explanation. In either case, elasticity may be conceivably an embodiment of implicit knowledge and the relationships between parties. What we discovered is that diagnosing elasticity and establishing a metric around it provides us a lens behind the unspoken. We see this as particularly relevant for contracts, where having a deeper understanding of the linguistic framing is helpful for both parties. This is because embedded in the language is the DNA of each party's implicit position. Tracing these linguistic triggers, mapping them, and being capable of gauging their use is therefore significant in building robust contracts. So as I turn it over to my esteemed co-author and expert in reinsurance, we ask the question, how can we leverage the understanding of elasticity to provide better structured models for reinsurance?
Thank you, Dr. Ma. Brilliant. So I'll walk you through the process of taking unstructured data and arriving at elasticity score. So I'm hearing that the crowd is excited about insurance, so we're staying with the topic. So on the screen you see an example from a larger data set of reinsurance clauses, which we thoroughly analyzed and annotated throughout the process. And you see it's not a particularly complex clause. It just regulates the right of a reinsurer to access the records of an insurance company. Seems simple, but when you read it, it's not that straightforward, right? Insurance language is a legal language, so you have a double layer of complexity. But when you study it thoroughly, you will notice actually that there is a structure to it. And then you can use the structure then to measure the elasticity of the text you're looking at. So let me present you with our framework. So it's the Semantic Framework, which is the innovative approach of looking at the clauses and arriving at a score which can help you then taking hopefully better decisions. It consists of 2 dimensions. We have the semantic terms. On the slide here, they are represented on the right-hand side. We have the who, the what, the scope, the when, and the purpose. So these are variables which show up in every single clause. The second dimension is the semantic layer lens, which Megan already mentioned before. So this is the dimension which allows you to see whether there are any underpinning definitions which further clarify the variables we just looked at. Okay, so what does it mean in practice? Let's take one term of that particular clause. We see free access here, big in red. This is our what variable. With our semantic lenses, we also see that there is no underpinning definition. There's also no reference to a statute which can help us clarify that statement. But actually, we don't know. Maybe for the contracting parties, it is perfectly clear what free access means. Maybe it's also meaning which is used which is used commonly in the market. But are there truly no strings attached to this free access? We simply do not know. And by applying that framework here, we can actually zoom in and see what is the underlying intention of the parties. So we flag it to make the implicit information explicit and bring more transparency to the relationship. So it is our hope that by using structured approach to clauses, which we can then see them as data, and the moment you see law and clauses as data, you can start measuring what you see, you can start taking better decisions, and you can start using them strategically at your deal level, but also at the portfolio level. As part of the project, we had a chance to work with our developer at CodeX, doing a little prototype of that framework. So we have it already up and running with our data set we already have. So big shout out to Will and Henley. Thank you so much. In terms of the next steps, we want to expand the underlying data set with more diverse type of clauses. And then going forward, the goal is also to link it to the contract outcomes to be able to actually quantify the elasticity effect in a given contract. So if you have ideas how else we could take this project, it's still early days, would be happy to engage after all. We have the first publication of the research published, and the second one is coming up at Stanford website and hopefully on MIT journal as well. So thank you so much. Bruce, yeah.
This is really fascinating. You know, I've done some work with Munich Re. How would you apply this to equalize the imbalance in consumer contracts, the terms and conditions that we all sign into, and the elasticity of those clauses, and how rife with too much wiggle room that gives typically the corporation in those arrangements?
Yeah, that's a super question, actually. So part of our idea behind elasticity is bringing the implicit to the explicit. So what we see now is that people are using natural language, and this is the beauty of natural language, right? Because it's infinitely expressible. And so, but in this kind of infinite expression, we see a double-edged sword. So part of what we're hoping to do with elasticity and understanding actually how people are stretching their words is we find the intention and we package and unpack essentially what was behind these words. So how that would contribute in the consumer sense is there would be a stronger understanding, because all of this implicit knowledge that lawyers and those who are involved with drafting, so policy underwriters, have described as kind of expert knowledge, intuition, experience, that would all be out and explicit.
And if I can just add to it, right? I think there's this movement in the industry to make contracts simpler. And I think our angle is to it, yes, simpler, but maybe let's focus on the exact, not just to simplify for the sake of leaving the ambiguity when the dispute comes. That's also the other angle. Yeah. I don't know who is the microphone. Yes. Yes, so we're waiting for the microphone.
Thank you, and sorry for the delay. Thank you once again for the presentation. It was amazing, great work. Just a couple of questions. If you don't mind explaining again how you reached the color coding for the individual parts of the provision, and as well as the second question being, how do you link across multiple provisions in a contract? So let's say there are multiple provisions that are meant to be read together. Would this framework apply to that as well? Thank you.
Yes, that's a very good question, and that made me realize that I did not explain color coding in my short talk. Yes, so we use basically the traffic light system, where the amber right is the low elasticity, the red one indicates that there is a higher elasticity. Yes, sorry, green one being the low, the amber medium, and the red high. And this was the result of actually data annotation, which we performed. So this was the initial push. We are testing actually with different technologies at the moment, how to scale it, because the plan is not just to have it annotated, but there are different approaches, right, we can take forward. So from GPT-3 to the defining ontologies, right, to be able to scale it further. But that's, yeah.
And to your question about kind of multiple clauses and the interaction of clauses, so I think that is a direction that we're hoping to take. At the moment, what we did was because it's just me and Claudia at the moment, so for the sake of resources, we zeroed in on one clause and specifically access to records. So that's so part of our next steps is to kind of look at clause-to-clause interaction.
Great, thank you guys. Okay, CodeX has a developer now? That's amazing. Definitely didn't yeah, yay! Definitely didn't have one when I was a fellow. Lucky you guys. Okay, final talk of this section of Lex Talks is about water law monitoring and management using the blockchain. We should all drink every time someone says blockchain. I'm realizing no. But yeah, so come on up, Bear. Please tell us about your project. Bear is the CEO of Treatise Technologies, Inc., an organization that provides blockchain for water management. And I didn't realize this when I started research on your talk, but water law requires so many variables. Understanding these variables from climate science, infrastructure, water diversion, usage measurements, agricultural usage, and social justice. So I'm sure you have thought deeply about these issues, and I cannot wait to hear what you have found. Please welcome Bear.
Thank you.
Sorry, everybody, just give us 1 second because we have a. And Ruben. Yeah. There's a very, very rough prototype hardware component here, so it's been tough to figure out how to make it work. All right. So let's get water into here. Yeah. Here, you want to pour it? Oh.
part of the experience. Okay. So yeah, I'm Bear Vasquez. I am with Atreides Technologies, and I have the pleasure of being a CodeX fellow this year. And today I'm going to talk a little bit about the revolution of water law and why that's particularly important today because of the laws that were enacted yesterday and the technologies we're going to use in the future. Next. So I want to start off with a little icebreaker and just ask everyone to themselves to think, what is the value of water? If you had to give your just best guess of how you value that resource, and ask yourself, what metric do you use to value that? As you identified earlier, there's quite a few different impending intersectionalities in there. And so you ask yourself, how do we value it? And most oftentimes it's through a mechanism, a market mechanism. And if you think, isn't it strange that there's a market for everything? There's a market for sneakers. There's a market now for used dog toys. But we don't yet have a market for water. Not a good working one, at least. Thank you. Next slide. So I want to just start today off with the present, which is something that everyone is aware of, which is the impending issue of water scarcity. Right now, there's competing usages, and that's one of the problems. I see that there's some glitch with the slide. Are we able to clear that up? Thank you. So the question is, how do we divert water, or how do we appropriate it amongst competing usages, which all might have an equal claim to water? 3 being agriculture, environmental, and municipal. And so the obvious answer is most often, well, why don't we augment supplies? Well, water is a finite, non-renewable resource, right? So augmenting supplies is costly and timely. That's the case with desalination and water recycling. Water sharing offers a different opportunity. Next slide. So water sharing allows water to flow to its highest value, whether that's environmental, whether it's social, whether it's economic. The problem with that happening right now is the impracticalities of water law as it exists, and as it has existed almost unimpeded for over 100 years. So water's an uncertain property. It's a usufructuary right. There's a question of whether or not that right belongs to one and whether or not government can step in and use public trust doctrine and like legal doctrines to take it. And so that has impeded a fair market thus far. And notwithstanding that, the prior appropriation system, which is revamped across the western United States, has some arduous technicalities to it. We see that in a use it or lose it form or a third-party harm inquiry. And essentially what that means is that conservation has difficulties being promoted because it's not yet clear within varying court systems whether or not that's a beneficial use. Likewise, if there's a trade of water that is going to happen, there has to be a difficult ecological and legal calculus as to whether or not that trade will cause a downstream user, in the case of a river, any sort of harm or will impede their usufructuary right. So the question is, why don't we just revamp the laws? If it were only so easy, because there's not much disincentive. I mean, there's much disincentive there, both from the stakeholder side and from the court side. We know that the legal system is not the quickest to innovate of all the industries. And so there's that hurdle. And we also think about the end user who holds most of the rights in the United States. It's agricultural users. And so there have been beneficiaries who have been able to capitalize on the uncertainties and inefficiencies of the system as they exist now. And if you look at the Supreme Court docket over the past few years, you'll find more than a few interstate water disputes. States aren't even able to have accurate understanding of their rights or who holds them or the over-appropriation of different bodies of water throughout the states. Lastly is the fragmented administrations themselves. If you look in any given state at the local level, at the state level, and even at the federal level, there's mass confusion and uncertainty regarding the rights and their ability to be transferred between parties. Next slide. So then we get to the future. The future, as we are perceiving it and projecting it, is Atreides. And we're working towards that future by putting water on the blockchain. And essentially what that does is it clears 3 hurdles. We're improving transparency with water resource data by having a universal, accessible point of truth. Second, we're able to create ledger histories of transactions that have not yet existed. Quite literally, they're often paper-based systems that are in county courthouses and inaccessible by the general public. A third is an important ingredient to this is de-risking the potential and opportunity for private capital, which has so long not been involved in our infrastructure improvements and in investments for conservation measures and opportunities between resources. Perhaps most importantly is the reduction of transaction costs between parties. So our person-to-person platform and peer-to-peer architecture offers the opportunity for parties to seamlessly transact with one another, to be united and to find willing, interested buyers and willing sellers. And second, we have IoT monitoring. So we're using Internet of Things to be able to have real-time monitor systems to evaluate the presence of our resources as they exist today, and hopefully forecasting what their state of existence will be tomorrow. And we're able to do this in any given jurisdiction, in any given resource district, through smart contracts, which undergird our system and allow them to uniquely meet the frameworks and needs, regardless of the legal system which governs any of those districts. And our tokenization process allows an economic mechanism to align incentives in a way that they haven't been before. We are providing agricultural users and industry players the opportunity to fractionalize their water rights, for more water to go further, to use less water. And in down times during droughts or whenever the economy in the agriculture sector takes a dip, to be able to immediately liquidate and or monetize a right for a positive conservatory use. Next slide. And so one of the things that we're going to show you today is the main theoretical impediment that has been experienced. I'll say, when Mr. Musk was previewing the Tesla truck, I remember he threw a sledgehammer through a window. If anyone can recall, it wasn't bulletproof. So we're not yet, I guess I would try to say leak-proof, but we're trying to get flow to go through there. So while my colleague works on that, I'll touch on the question of how we're going to do it practically. So the theory of change is a first mover advantage and being able to be the first pioneering group or organization that tries to achieve such an ambitious goal. And we've articulated out our strategy by targeting 25 different water markets in the western United States. And they've been targeted based on 3 criteria. Number 1, insularity from state law, which impedes transactions or which doesn't map on readily to the transfer of resources between parties, whether for social or economic good. Second is the accuracy and capacity of the registries which currently contain water rights. And then third is the degree to which the state in which those water markets reside in are receptive and or advocates of new emerging technologies, specifically in the Web3 domain and blockchain. And our idea, which we believe very strongly in, is that more markets will follow. Why? Because it's a clarification of property rights. We're able to ascertain what the consumptive right is, what the diverted right is, and what the ultimate use right is for any given resource jurisdiction. Second, I also mentioned we're able to introduce private capital into these communities which are lacking and have suffered from the stigmatic transactions that might be known as buy and dry scenarios, which we might have seen in the Wall Street or New York Times as of late, where we have the erosion of agricultural communities across the West. Third is we're improving the ultimate productivity of water as we see economies restored and preserved through expansion into the arid West, and we see urbanization happening in areas like Colorado, outside of, and in suburbs such as Denver. We're going to be able to promote a mechanism and an opportunity to preserve those communities as they exist now and to continue pioneering into the West into the future. Next slide, please. So that's how we're going to do it practically, but what does this mean for the practice of law? And that's what makes this so fascinating, is never before that I'm aware of has there been a time in which you see a unique intersection between law, which is decided almost completely on the basis of historical tradition and practice, coming at a headwind with futuristic technologies to try to initiate a problem, or a solution rather, for a problem that exists present day. And so what we're hoping to do is, with the achievement of the strategy and the execution of that strategy that I just articulated, that we're going to see basin adjudications happen across the United States. And we have perhaps our bulletproof Cybertruck window. Ruben is the real MVP, if others can't tell.
They were supposed to give a long speech about how this is a prototype, but we glossed over that. It's supposed to be stopped now, so it's okay.
Okay.
We'll turn back on when it connects with the blockchain.
Perfect.
You can watch what's happening over here on the terminal.
Yeah, absolutely. So I'm going to ask everyone to use their imagination here. And if we all had our Oculus VR systems on, what you would see in this bucket is actually a reservoir or a resource jurisdiction. Think of the Central Valley of California in this bucket. And you're a water user, and you have water, and now you're actually irrigating your crops. What you're seeing right now is you're seeing the use of that water happen and being measured in real time, and it's all running completely on chain. Right now we're running on Ethereum, but we have anticipation to create native token assets to where it wouldn't run and you wouldn't see the accounting or transaction of monies being drained from the account, but rather tokens that were minted for the Central Valley of California, a one-to-one token, where tokens actually represent, through NFTs, your right, and you can actually see the burning of those tokens as you use more water on your crops. What's that? Microphone? Oh, okay. Is this okay? Perfect. I hope. So, back to what I was saying with the revolution of legal doctrine, is once we see basin adjudications take place, that's the determination, that's the certain determination through the court system of what any given legal right is. As I mentioned earlier, there's often a disconnect between the right that's held and what actually happens and gets used in the field because of the lack of monitoring infrastructures and systems. And so what we are anticipating to happen is an unbundling of rights as we introduce these technologies into these marketplaces and into these districts. And they provide an incentive, an opportunity for the state to step in as an alternative to expropriation, for the state to become a player in this market system, for the state to participate and to actually fund and provide capital opportunities to promote conservation and environmental efforts. And lastly, it's a preservation of the judicial economy. As we see administrative activities and new water control boards pop up across the United States, it's an opportunity for the courts to untether themselves from the consideration of water rights in the states, of new infrastructures for more developed ecological purposes and concerns. Next slide. And so I just leave everyone here. It's such a fantastic event with the idea that what we're doing is ambitious, and what we're exploring is new pioneered ground in terms of technology, in terms of new ways to revamp law and policy as it concerns natural resources, and to further explore and consider how we continue to create more value with these resources. And with that, we're hoping to unlock the value of water today with the technology of tomorrow. And if you just give me one moment, my colleague Ruben is going to show you our dashboard mechanics and actually everything that's happening live on screen in the California Central Valley. So what you can see right now is a dashboard for an end user. Earlier I asked you to use your imagination and to consider that you were a farmer in the Central Valley and you have a compendium of rights. These rights are represented by NFTs in this system. And the question is, how do you prevent someone from using a right that they've already sold? How do you connect the physical with the digital? And right now, Ruben is going to sell a right to me in my account, and hopefully our system is going to prevent the flow and the further use of this water. If the network speeds allow. And has it gone through yet? Okay, that's what I thought. Yeah, absolutely. Please help me continue to work through this. Did we get the notification? Or did we run out of water? Thank you. Yeah. We'll take questions. What's that? Oh. Well, there you have it. Aha, there is water still in here. Yeah. We'll have to find an alternative to the Robson network. Maybe we'll do Ethereum mainnet next time. We'll run a little quicker. With that being said, I don't want to take any more of anyone's time. I know I'm over, but I perhaps have time for maybe one or two questions. If not, I'm more than happy to take them afterwards.
Yeah, I had one question. So, super cool demo and implementation and vibe you got going up there. I'm loving it, man. But how do we verify the identities of the water purchasers, right? Because so many people with wallets might walk in here and, let's say I want to buy rights to, access a certain pipe or water, and I haven't doxed myself, right? I just have a DID right here on the Ethereum or Robson test network, yep. And I haven't, where's the metadata that actually tells the water where to go?
Sure. So this has to do with a strategy that's been approached through a back-end regulatory infrastructure context. So what we're able to do is everything will be privatized as far as wallet identity and ownership of an NFT or water right. But the administrators on the back end also have a manager-facing platform that allows them to identify, at least locationally, geographically, where usage is occurring. Yes, so thank you so very much.
Thank you so much.
Yeah.
That was
Yeah, thank you.
really great.
Absolutely.